We are back, and of course, we are live on X Spaces, on YouTube and Facebook. As usual, you can drop your comments there. We'll share it with the rest of the world. This is The Pulse here on Joy News. Independent, fearless, and credible. My name is Elton Broby. Well, this afternoon, the John Mahama-led administration is moving to introduce legislation, in fact, a legislative instrument that would establish new rules for the removal of Supreme Court and other Superior Court judges. The announcement was made on the floor of Parliament by the Majority Leader, Mahama Yariga, amid an ongoing process to remove the Chief Justice Gertrude Tokono. That process, currently underway, has drawn sharp criticism from the opposition MPP, which claims it is a deliberate attempt by the NDC to oust the Chief Justice unfairly. We'll hear from Mahama Yariga shortly on what government plans are to protect this particular office. But first, here is Deputy Minority Leader Patricia Piaget, who has described the move as shameful, an effort to undermine judicial and stuck the Supreme Court with NDC loyalists.
Malicious attempt by the presidency to undermine judicial independence have reached dangerous proportions. The nation watched in disbelief as the executive launched brazen efforts to remove the Chief Justice of the Republic. An assault not merely on one officer holder, but on the very sanctity of the judicial branch. At the same time, the president is seeking to pack the Supreme Court with loyalists. 7 nominations in one swoop, clearly designed to bind the hands of the Judicial Council and tilt the highest court in the land towards executive interest. Equally troubling is the identity of the legal practitioners leading this crusade. While the right to counsel is sacrosanct and every citizen is entitled to legal representation of their choosing, it is profoundly disquieting that the lawyers spearheading the campaign against the Chief Justice are individuals publicly known to have represented or are still representing both the President and the Speaker of Parliament in active legal matters.
All right, so this is the opening remarks from the minority side as Parliament, is back in the House today to begin government business. Now, the Parliamentary Affairs correspondent, Kwaku Asante, joins me on via Zoom. So, Kwaku, I'm curious to know the Majority Leader's explanation for these new rules that government is seeking to introduce to Parliament.
Like a bombshell that the Majority Leader did drop, because the Constitution provides in Article 146 specifically the rules that will lead to the removal of a Chief Justice or Justices of the Superior Court. And so in his opening remarks, and one would be open to accepting that that was sort of a response to Patricia Piaget's claims about the NDC seeking to pack the court with NDC loyalists. He dropped that shell that the Attorney General is expected to lay legislative instrument or critical instrument or that will enact new rules that will guide the removal of judges from the Superior Court. As you know, Article 146 introduces specifically what the rules will be, and the courts have, on a number of occasions, also interpreted what those rules are about. And so he does not say specifically whether this will come by way of a constitutional amendment, because Article 146 is an entrenched provision, and if you want to change any part of it, you would have to go through a referendum for that change to become law. But listen to the Majority Leader himself in his own words, explaining what he says is the commitment of the President to ensure that the judiciary is not actually easily dealt with or, in their own words, removed from office.
By the time we finish passing these bills, the legal architecture of Ghana would have received a significant overhaul. Right, Honorable Speaker, the Attorney General will also introduce several subsidiary legislation. They include the corporate insolvency and restructuring regulations, the Court of Appeal rules, Economic and Organized Crime Office Operations Regulations, Economic and Organized Crime Office Terms and Conditions of Service Regulations, High Court Civil Procedure Amendment Rules, Interpretation Regulations, Judicial Service Terms and Conditions of Service Regulations, Legal Aid Commission Regulations, Supreme Court Rules, and very significantly, removal from office of justices of the Supreme Court rules. The President, John Dramani Mahama, is determined to fast-track legislative reforms to strengthen our institutions of governance and further entrench our democracy. The President is committed to legislative clarity with transparency when it comes to the constitutional mechanics of the removal of justices of the superior courts.
So, I wonder whether there's already been reaction to this proposal by Mahama Yariga to the floor.
On the floor, while he made these remarks, the minority, obviously, and some of them, as we hear from the video, they shout, and other things. Some of them were taken aback, they were a bit surprised about this. But because he was the last leader on his feet to speak, there was no rebuttal really from the minority front bench or any person for that matter from the minority side, except that later on the speaker himself did make his opening remarks where he spoke generally about issues having to do with Parliament and national issues. He did not touch on this removal of Superior Court judges. But this is certainly something that we'll be hearing something from the minority on, perhaps in the days ahead or even today, because it will be interesting to see how exactly are these rules fashioned and how will they sit in tandem with the Supreme Court. Will this merely be legislative instruments, LIs, CIs, and other subsidiary legislations, which will be subservient to the Constitution of the Republic, or the government intends to amend the Constitution to change the process that has been outlined in Article 146 of the Constitution? So yes, officially, no response yet from the minority or any person for that matter in Parliament, but that is something that will certainly draw reaction. Except that earlier today, I did speak to Vincent Ekwase, a member of Parliament for Old Trafford, who did go to the Supreme Court a couple of weeks back, challenging the processes to remove the Chief Justice. His judgment is out, that 80-page judgment that has simply been in circulation over the last few days. He did say that he was going to study that ruling and decide what exactly he would do, whether he will seek review or not. He says he's still consulting. But he was reacting to my question about the new affidavits that have been deposed by the suspended Chief Justice about some mental ordeal that she said the committee investigating the matter is subjecting her to. And she said, and he, I should say, says that it is clear from all that is happening and from the affidavits deposed to by the Chief Justice that they are certain underhand dealing to simply get Madame Tokolo out of the way, and she's not going to get a fair trial from that 5-member committee chaired by Justice Gabriel Scott Foreman.
I don't see why a Chief Justice will appear before a committee and he will be searched like a petty criminal. Meanwhile, the lawyers who are representing the petitioners are not searched. The lawyers who are representing the petitioners are given the free will to be able to take in their phones, their laptops. The indication is that they have some information on it. But the Chief Justice does not have the right and authority to bring information that is on her laptop or her phone to the committee. It cannot be a fair procedure. It cannot be a fair treatment.
So your understanding of all that is that there's clearly some attempt to gag or to unfairly remove the Chief Justice, or what do you see from that?
I have maintained right from the beginning of this process that the process is fraught with unfairness. There are a lot of procedural improprieties, and it looks as if somebody has made up his mind that by hook or crook, the Chief Justice will have to be removed.
Of course, Vincent Ekwase will join us pretty soon as we explore the latest twist to this ongoing process to probe the Chief Justice for allegation of misconduct. But before I let you go, just a matter that is not entirely related to this Chief Justice, but I heard Mahama Yariga make the point on the floor in his opening remarks that the Speaker should, in the matter relating to some comments Parliament deemed, derogatory relating to the former late President Judge John Rawlings, Mahama Ayariga makes the point that all backbenchers around the space that this, comment came from should be held responsible and made to appear before the Privileges Committee. Did the Speaker rule on that?
We know that it was last meeting that comments were made. That comment, the Death of the Murder comment. We recall that the Speaker of Parliament gave the said Member of Parliament, whose identity will be not known yet, 1 week to reveal himself. And as of now, 2 months on, no one has come forward to say that he was the one. You heard there the majority leader rightly say, like you said rightly, that they are very incensed about that comment, and they're not going to let it go. They are insisting that if the Member of Parliament who made those comments do not come, they believe the comment came from a certain direction, and that group of people must all be held responsible by being sent to the Privileges Committee of Parliament to answer questions. The Speaker of Parliament, while he was making his comments, also did take him at that and said that Parliament was still investigating the matter, and that for him personally, it is disappointing that the Member of Parliament has not come forward, and also that no one in Parliament seemed to know who made that comment. He says it's very disappointing that MPs can claim that they do not know who made those comments, and that he, as head of the legislature, will continue to investigate this matter to the very end. He says, and in fact, back in the point Mahama Ayariga made, that the comments were made, and in fact, he zoomed into 3 members of Parliament, he said, sat at a particular place in the minority benches. He actually says that when those comments were made, the minority leader, Alexander Penny-Markin, who at the time was on his feet, let turn his head to look at the said Member of Parliament. And so he's surprised that neither members on the minority side or even the majority side who are facing these MPs have been able to come forward to name specific persons who must be investigated for this. But he says he's committed to investigating this to the very end.
So it's first day in Parliament, and already so many things to chew on. Kwaku, thank you so much for joining us this afternoon. And of course, this afternoon we are spending so much time on the matter relating to the suspended Chief Justice and matters that are coming out as a result of the ongoing process. Now, Gertrude Tokonu has described the ongoing investigation by the Gabriel Praman-led committee to potentially remove her from office as unjust and a blatant mockery of justice. In a supplementary affidavit filed at the Supreme Court registering support of a motion for an interlocutory injunction, Justice Gertrude Tokonu expressed concern over what she termed persistent violations of her constitutional rights and a sustained assault on judicial independence. The Attorney General, Dominic Ayine, has swiftly rejected all her demands, and we will share that with you shortly. But first, let me bring you the details of the CJ's affidavit for interlocutory injunction filed at the Supreme Court. So there you have it on your screens, and she's making certain demands. She says, I respectfully seek leave of this honorable court to bring to the court's attention various developments since the filing of the present application, which evidence a complete desecration of my basic constitutional rights to a fair trial, violation of my dignity, and subjection to inhuman and degrading treatment of a kind not meted out to even accuse persons on trial for treason and other offenses against the state. And he says, I was informed by my lawyer, Kwabena Adukusi, that the proceedings of the committee set up by the president to inquire into the 3 petitions filed against me had been adjourned to a day after the commencement of our action in this honorable court, that is the 22nd of May, 2025. And then on the 22nd of May, he says, I appeared before the committee together with my lawyers and informed the committee members of the suits I had instituted against the Attorney General and the committee members, in response to which the committee requested to receive copies of the processes filed and adjourned proceedings to the following day, Friday, 23rd May 2025. And so on the 23rd of May, the day after, she says, notwithstanding receipts of the processes filed in the Supreme Court, including the application for interlocutory injunction, the members of the committee indicated their resolve to proceed with the conduct of the inquiry. And this was so according to, even though, he says, even though I have to date not been told the basis for the determination of the prima facie case against me and the specific allegations in respect of which the prima facie case has been established for me to answer, to enable me determine my legal rights or adequately prepare a defense to the charges against me. She goes on to say that the committee refused to recognize my counsel simply because I was not personally present, and proceeded to fix a subsequent hearing days and make arrangements for the hearing without involving my counsel, even though he was present. The committee, shockingly, according to her, simply refused to recognize the same counsel on whom it has served a hearing notice only a day before. Now, Getutokonu goes on to say that other developments like the denial of access into the hearing room for my husband and children, searches on my body, denial of access to telephone and laptop for myself and my lawyers, even though counsel for petitioners have access to their phones and laptops, and the conduct of the hearing itself in a highly security zone at the premises of the castle also shows a deliberate effort to subject me to mental torture and degrading treatment in violation of my fundamental rights. He says, all Article 146 proceedings, with the exception of the one I am being subjected to, had hitherto been held in judicial facilities, specifically the courts complex. The location of proceedings affecting me to a cordon high security facility boggles the mind. And he said the persistent violation of my constitutional rights show that the whole proceedings initiated against me are a mockery of justice and a ruse to unjustifiably remove me from office as the Chief Justice. And she is praying the court intervention by the grant of an injunction to prevent the assault on judicial independence and protect the security of tenure of the Chief Justice and justices of the Superior Court of the Republic. And so this is what Getutokonu in an affidavit has presented to the court with the hope that she will get a response. Well, the Attorney General, Dominic Anine, has a quick response for the suspended Chief Justice and a lot of things that she has, the Attorney General has been saying in response to what the Chief Justice Getutokonu in that affidavit presented to the court. And amongst them, the AG says that the in-camera hearing is a constitutional command geared at safeguarding not only the CJ but the entire judiciary. It can therefore not be waived. The AG said there is no basis in law for the two Supreme Court judges to be restrained from participating. And in concluding on this, the AG concludes that the case of injunction has not been made out. And so that's the response to the AG. But the court is yet to sit on this particular matter for us to have a conversation on it. Now it's a good time to bring in some legal brains for their perspective on this matter. Now joining me on phone, of course, privilege as always, to have Mr. Kwaku Ansari, a former director of the Ghana School of Law. Mr. Ansari, good afternoon, and always a pleasure to have you here on the pause.
My pleasure to you. So good afternoon.
Right. Also joining us is Justice Abdullahi. We don't have him yet. We'll bring him on. But the Member of Parliament for Old Safo, Vincent Ekwa-Safwa, is also joining me via Zoom. Honorable Member, good afternoon. Welcome to the program.
Yeah, good afternoon.
Right.
Thanks for having me.
Great. So let me start with you, Mr. Ansari. What we are just learning this afternoon is that the majority leader has given indication that government may in the coming days present, is unclear whether it's going to be a constitutional instrument to Parliament to guide the removal of Superior Court judges. What will be your response to this?
Well, thank you very much. I think it's a step in the right direction because so far the current CG removal process has attracted a lot of comments. And there are some people who are suggesting that, we should have guidelines to guide any committee that may be set up by the president to probe the CJ. But I can only hope that it is not an ad hominem committee that is geared, for the sole purpose of streamlining, the removal process concerning leadership get to talk of it, and that it is going to be something, that will be long-lasting, for the future, not, to regulate. Because at the time that Article 146 was triggered, there hadn't been any such law or regulation. So if a CI is going to be passed, then it should be not only for this, but for the future, to be a guideline for the future, not for the present. Because at the time that the committee was established, there was no such CI.
And it's interesting because this is one of the main issues Mr. Eko Asafua and his lawyers went to court wanting to understand, the procedure. In fact, at the first hearing of this probe into the allegation of misconduct on the part against the CJ, we are told that the lawyers demanded to know the rules governing this particular exercise, and they didn't get any. Now, why is this coming at this time? Government has yet to provide justification, but what, in your estimation, could be the motivation behind this government move to have rules and regulations to govern the process?
I should like to believe that it's a step to accommodate the worrying concerns, of the public. We now have a divided opinion as to whether or not what is going on should have been begun in the first place. But I'm glad that at least the powers that be are listening to public opinion. It's so far so good. It's good for democracy. It's good for the country. It's good for independence of the judiciary. So that it's not only, Justice Tokonu, but it is for justices of the superior court. And, I should like to think also that it will be extended to cover personnel of the judicial service as well. As I said, it shouldn't be seen as something that is being passed solely, to provide some comfort, for what is going on. But that the government is a listening government and has considered so far the views, of cross-section of Ghanaians, and wants to do, what the society at large, perhaps, is expecting of the president.
All right.
If he's the president for the father, for everyone, he's listening and he's saying that he's going to initiate legislation in the form of a constitutional instrument to provide a framework, for the guidance of the CJ removal process. I think it should be better.
All right.
It shouldn't be seen to be targeted, as leadership. They should talk about.
All right. I'll come back to it because we have a lot to unpack on this particular matter. Let me bring in the Member of Parliament for Old Tafo in the Ashanti region, Vincent Eko Asafua. He's also a legal practitioner. So, Honorable, you've heard your leader in the House. He says government will, in the coming days, present some rules. I don't know in what form that rules will come. Now, when I posted this on my X, the conversation around this, for example, one Kwame Asofie is saying that you want to remove this one, that's the current Chief Justice, and then lock the door. Is that the same vibe you are getting, Honorable?
I couldn't have agreed with him more. Of course, it's also a vindication of my earlier position that the framework within which a Chief Justice will have to be removed is simply not a perfect one. And if it is not a perfect one, of course, people who advocate for constitutionalism, people who advocate for literalism, people who advocate for the black and white of the letter of the Constitution will argue that that is what the Constitution is now. But I am of the opinion that it is a vindication of my earlier position because they themselves are agreeing to us that we don't have a perfect system, and for that matter, a purposive interpretation of the Constitution would have led to a reasonable conclusion. And so if they are saying that they are going to introduce a legislation in Parliament to regulate as to how a Chief Justice will have to be removed, it tells us that the Henrietta Mensah Bonsu kind of decision that she gave is one that we should probably go with. But of course, they have every right to bring the legislature to Parliament. When it comes, I'm sure the Constitutional and Legal Committee of Parliament will initially, if you like, deliberate on the legislation clause by clause. and members of parliament will also have the opportunity, also on the floor of the parliament, to be able to also debate him. And if you like, make some amendment here and there. But it's a clear vindication that we don't have a fair system, if you like, a perfect system as to the removal of the Chief Justice.
But again, I'm curious to know, I mean, you are a member of parliament, you're also a lawyer. I know that Article 146 is an entrenched position. So indeed, for education, what in your mind is government seeking to do exactly? Provide guidelines or what exactly?
Well, as we speak, I don't know what they seek to do. As I said, well, on the floor of parliament, I just heard the leader saying that they are going to bring a legislation to parliament to regulate, if you like, make some amount of amendment as to how the Chief Justice will have to be removed. My interest is that just the admission that they have to make an amendment. So if you like, they have to regulate how a Chief Justice will have to be removed is a total admission that the system that we have is not a perfect one. It's not a perfect system because how a Chief Justice will have to be removed should be one that should have a very huge threshold. You should have a very huge threshold to the extent that in removing a Chief Justice, you should find it very difficult to remove a Chief Justice. It should not be on the basis of any frivolous or if like vexatious accusations or if like allegations against the Chief Justice. So we are waiting. It is on that basis that you've not really heard anything official from the minority side. We want to see how they want to go about this kind of, if you like, legislation that they want to introduce to the floor of parliament to see how such an amendment will go.
All right. Again, Mr. Ansari, I mean, now let's focus on this, affidavits, supporting affidavit that the suspended Chief Justice has filed at the Supreme Court, but virtually asking the court to come to her rescue. Now, she makes some very important points. One of them relates to what, in her estimation, could be discriminatory practices adopted by the 5-member committee that is probing her for allegation of misconduct. She makes the point that whilst counsel for the petitioners are allowed to use their phones and laptops during the committee sitting, she was denied that privilege. I mean, is this right?
No, I don't think it is right. You see, the Constitution in Article 17 frowns upon discrimination. And therefore, if parties appear before a committee and one particular party is giving certain privileges that will not be extended or accorded to the other party, I don't think it is nice. It is discriminatory and flies to the face of Article 17 of the 1992 Constitution.
But is she right to demand that her husband and kids are allowed into the committee room?
Elsewhere, this will be an issue at all because the spouse, the husband and wife, there's always some unity between husband and wife. And if the CJ, is appearing before a committee, I don't see what is wrong, in being accompanied by the husband. The truth of the matter is that no one knows the scope of the expression in camera, whether it is relative to the proceedings, the venue of the proceedings, or that the secrecy disables spouses from accompanying the party or witness. So I think it's all, maybe now that we are going to have a CI, streamlining the procedure, the time is right to consider this particular aspect. I think that the husband wants to accompany, or the wife wants the husband to accompany. I don't think the husband should be stopped or prevented from being in attendance. He's going to be in attendance only. After all, the witness or party is a spouse of the man. So I think the committee will have to reconsider the tough stance and allow the husband to be there. It doesn't hurt. How is it going to hurt the committee if Sokonu's husband is in attendance.
I mean, Honorable Asafua, the Chief Justice concludes that this is a calculated steps by the committee to pronounce her guilty even before she appears before, in view of the challenges she's going through in presenting herself. Has she got a case here?
I think so. You see, the Chief Justice, is Chief Justice of the Republic. There are certain privileges.
But Honorable Asafua, if you can hear me, that question was actually for you.
Yes, I can hear you.
Yes, yes, please go on.
Yes. So
yes.
absolutely, I think that the Chief Justice, has a case. I mean, she has every reason to believe that this is an orchestrated attempt to, as it were, remove her from office. Why? Because actions and inactions of even persons of the committee, as we speak, suggest that she's not going to have a fair procedure as far as the regulation of the committee and its actions are concerned. Why am I saying so? I had the opportunity to read the supplementary affidavit of the Chief Justice, and the Chief Justice makes allegations that she enters into the room, she is searched like a common criminal. Lawyers of the petitioners are allowed free access to the room. In fact, they are allowed to enter the room with their laptops and their phones. The Chief Justice is not allowed. When the Chief Justice was appointed, or if was nominated and appointed by His Excellency the President, and when she was coming to Parliament for her vetting, she came with her beloved husband and probably the kids. On what basis is it that she's going to be removed? And there has not been any definition whatsoever that says how an in-camera will have to be done. And you say that she cannot have the moral support of her husband. Why are we seeking to incarcerate the Chief Justice? On what basis are we making such decisions? It's as if the decision has already been made. The committee is coming to the fore, if they are coming to the inquiry table with their decision already in their pocket, bent on making sure that they remove the Chief Justice. Other than that, I don't see why, even if you want to make sure that justice is served, you don't want to portray that justice is indeed served. You have to let Ghanaian people, you have to even let the Chief Justice be satisfied that justice has been served. In the event that she even feels that justice has not been served, even though the Constitution has not been made or stated clearly as to whether the Chief Justice may have a right of an appeal. But in my estimation, the Chief Justice, even after the recommendations of the committee, should have a right of an appeal to exhaust every kind of avenue to her before she will have to be removed. In that instance, the Ghanaians and other international community will feel that the right has been done.
But must she necessarily have a say in the venue for this kind of exercise? I mean, what is wrong with holding it at the Osu Castle?
There's nothing wrong with anybody choosing whatsoever venue. But what is your interest in fixing a venue at a highly security zone like the Osu Castle? As soon as you get there, the security apparatus and the security architecture that you see there even put some mental disorder on you. It puts some stress on your mental capacity. Why don't we have a friendly environment with a friendly forum whereby the Chief Justice with the husband and the kids, or if the children, will be able to have, a friendly opportunity to be able to head. As we speak, even the basis for forming a prima facie against the Chief Justice, on what basis she is now appearing before the committee, has not been given to the Chief Justice. How is she going to defend herself? She should be given enough opportunity, enough information to be able to prepare her defense, as it is stated under Article 19. As we speak, she's not having that. And it's an affront to rule of law. It's shameful, it's worrying, and it's troubling. This should not be happening.
Mr. Sassari, I mean, I asked Vincent about the venue and whether she should be involved in choosing where to have this particular sitting. She is clearly not happy with the fact that this proceedings is taking place at the Osu Castle, a former seat of government. I mean, should that be a concern at all? Should this one also be a matter for contestation?
I think it should be a matter of worry concern, not only to Sokonu's lawyers, but to the whole nation. I keep reminding the public that the Chief Justice of the Republic of Ghana And therefore, any treatment that will tantamount to indignity, to render her infra-day, should, be discouraged. Now, if you look at Article 18, that deals, with fair trial, I should like to think that, considerations of public policy, public morality, health and safety. So if they choose a venue that is not going to be authentic, to attendance and other things, I don't see why the Chief Justice of the Republic, cannot have a say, in the venue of a trial. I think as far as that issue is concerned, the Chief Justice, has a case. And I think the committee must relax. The committee must be flexible enough to accommodate, the interests of both, parties, the petitioners as well as, the Chief Justice. Even though the Chief Justice is on trial, he is not an accused person to be treated just like any ordinary accused, person. The rules, of fair play, fair trial, must, be made and facilities, made available to her at all times. We should always bear in mind that it is the Chief Justice of the Republic, who is being probed, and not an ordinary, justice of either the lower court or the superior court. I'm glad that CI is going, to be prepared, to provide guidelines, way to serve the entire nation. Once that is done, and all these worrying concerns are situated, I think, we are getting somewhere. The whole world is watching us. We need not let them down.
And then finally, briefly, I mean, do you support her call that the entire process must be put on hold until the Supreme Court determine all the cases that is before it relating to this probe?
No, I have expressed a view, already, that I don't think that the process should be halted. Any attempt to halt it will, be unconstitutional. And if she brought an application, sometime last week, I did point out that 3 or 4 applications have already been judicially considered.
Right.
And a pronouncement has been made. So those pronouncements should guide any future application, in like manner. Under Article 129, Clause 3, like cases must be treated alike. And that is, the whole basis of the doctrine of stare decisis or judicial precedent. And we cannot, be indulging in this back and forth injunction game. It has not become like, table tennis, ball is on the table. And until the ball drops, the injunctions, keep flying here and there. So litigation must come to an end, and it is in the interest of not only the Lady Chief Justice, but the entire nation, that this whole controversy, this whole CJ removal process that has now engrossed in political controversy, will come to an end sooner rather than later.
All right, we'll leave it here for now, but this is a matter that is, developing. So, Mr. Asansari, former director of the Ghana School of Law, thank you so much for your time. Also, thank you so much, the Member of Parliament for Ota, for Vincent Kwasefua, for your contribution to this discussion. The latest on this matter is that government is preparing to put before Parliament rules that will govern the removal of Superior Court judges. The shape and form we are yet to be told. We'll wait and get the details, and then we can have a proper conversation around this particular matter.